Good morning, everyone. I'm Harry Wilson, and Anna Joyce and I are excited to talk with you today about Martin v. City of Boise. Our firm, Markowitz Herbold, is sponsoring this session, so I get to share some information with you about our government practice before we begin. Markowitz Herbold represents cities, counties, and elected officials with complex litigation, including contract disputes, development agreements, election law, investigations, First Amendment issues, appeals, open meetings, public records. That's just to name a few. Our sweet spot is successfully resolving sensitive matters that are the subject of intense public interest. We staff our cases leanly, and given our experience working with governments and our ability to work efficiently and within a budget, our costs are competitive with most firms. Client service is also really important to us. We strive to provide a positive litigation experience for each and every client. At the conclusion of your matter, you will feel confident that we pursued every single avenue and turned over every stone to reach a successful outcome for your case. Thank you, and now let's discuss Martin v. City of Boise. Hello. Thank you to everyone at the League of Oregon Cities. Thank you for joining us. My name is Harry Wilson, and I'm here with my partner, Anna Joyce. We are at the law firm of Markowitz Herbold, and both Anna and I are very proud to have represented the League of Oregon Cities in an amicus brief in a petition for review of the case Martin v. City of Boise. Anna and I are here to talk a little bit about what that case means, what its implications have been for cities in Oregon, and what the future looks like. So thank you again very much for having us. I'm going to turn it over to Anna, who's going to start.
Thanks, Harry. So I'm going to start a little bit by just describing the decision in Martin versus Boise, what led up to it, and then I want to talk about a subsequent decision that came out of Grants Pass that extended the decision in Martin versus Boise somewhat. So in Martin versus Boise, 6 individuals brought a lawsuit against the city of Boise, alleging that their citations for violating public camping and sleeping ordinances violated the 8th Amendment. And the 8th Amendment is in the United States Constitution, and it prohibits cruel and unusual punishment. One thing I want to note, because it'll become significant for our discussion about what the decision actually came out as, is that at the time that the lawsuit was brought, Boise was not enforcing those ordinances when there was no available space in overnight shelters. And in fact, the city of Boise had teamed up with the police department and the shelters and worked closely with the shelters to develop a system where the shelters would notify the police department if the shelters were full on any given night. So the 6 individuals brought this lawsuit. The district court, the lower court, ruled in Boise's favor. The 6 individuals then appealed to the 9th Circuit. And the 9th Circuit is, I believe, the biggest circuit in the United States, and it includes Hawaii, Oregon, Washington, California, Alaska, Montana, Idaho, Nevada, and Arizona. And I point that out because when Harry takes over, he's going to be talking about the impact of the decision. And given that there are so many states in this circuit, the impact is significantly larger than it would be if it had come out of a different circuit. On appeal, the court concluded that the Boise ordinances that barred public camping and sleeping did in fact violate the 8th Amendment because those ordinances criminalized the status of homelessness. And the reason I do air quotes around status is because the 9th Circuit based its decision on 2 United States Supreme Court opinions that have concluded that governments cannot punish a status as opposed to conduct such as public drunkenness. So the court concluded that when the police are citing individuals who are homeless, they are punishing an individual because of the status of homelessness. And what the court concluded is as long as there is no option of sleeping indoors, the government cannot criminalize indigent homeless people for sleeping outdoors on public property on the false premise that they had a choice in the matter. Therefore, unless a city can show that there are available shelter beds and individuals simply aren't availing themselves of those available beds, any enforcement of anti-camping or anti-sleeping ordinances is unconstitutional. And again, this is where what Boise was doing in terms of not enforcing the ordinances when the shelters were reporting as full comes into play, because Boise was in fact attempting to do that. But the court noted that shelters might not be practically available because of certain rules or features, such as limits on stays, particular religious messaging or requirements of attendance at church services, and limitations on check-in times. After the Ninth Circuit's decision came out, Boise sought what's called reconsideration. So basically asked the Ninth Circuit to reconsider its decision. And in fact, asked not just the 3-judge panel, but the entire Ninth Circuit panel, which is I think about 13 judges, to reconsider and change its mind. Unfortunately, the court denied that. But what was interesting about the denial is that there was a dissent that was quite lengthy and highlighted many of the problems with the Ninth Circuit's decision in the case. And the dissent noted that in concluding that Boise couldn't enforce the ordinances, the judges in essence have put themselves in the role of public policy making with respect to how cities handle the homeless epidemic. The dissent also noted that the conclusion was inconsistent with what the Supreme Court has held in other 8th Amendment cases, and noted that courts regularly uphold ordinances that ban, for instance, public urination. And so public sleeping shouldn't be any different. The dissent also noted that Boise wasn't criminalizing the status, but rather the act of camping without permission. And finally, the dissent noted that the Ninth Circuit's decision leaves cities with the option to either spend a lot of money to provide housing or to figure out a way to count the number of homeless each night, or simply to abandon ordinances that are aimed at protecting health and safety. And Harry's going to talk a little bit later about that very issue and how we've seen cities trying to reconcile what they can do in light of this opinion. The city of Boise filed a petition for review with the United States Supreme Court. And as Harry mentioned in his introduction, League of Oregon Cities, with our assistance, filed an amicus brief, which is a friend of the court brief in support of Boise's position. And we urged the Supreme Court to hear the case and to reverse the Ninth Circuit's decision. And in that brief, we highlighted the really unworkable nature of the decision and the fact that other states and other circuits have concluded that enforcing these kind of ordinances isn't that constitutional. There was a lot of interest, a lot of support for the court taking this, and unfortunately, given the number of petitions for review that the US Supreme Court gets, and given the very small number that they grant, this wasn't one of the ones that they granted. So the Ninth Circuit's decision in Boise is binding law in the Ninth Circuit. And we're going to talk about the impact of that and how it's been extended. The next case was a class action case that was brought in Grants Pass, and it's called Blake versus Grants Pass. And this was a class action of homeless individuals who alleged that Grants Pass's ordinances and practices punish people because they are involuntarily homeless. A particular note is that Grants Pass has no homeless shelters. So when you think about the Boise v. Martin decision, and it talks about the importance of being able to show that shelters are full, Grants Pass can't do that because it doesn't have any. It does have a gospel rescue mission, but that shelter does have significant restrictions and conditions on who can stay there and what they can and cannot do when they are there. After the Martin versus Boise decision, Grants Pass reviewed their ordinances, their anti-camping and anti-sleeping ordinances, and removed the word sleeping from its anti-camping ordinances so as to try to distinguish sleeping from camping. And I think that what they were trying to get at is, again, that distinction between punishing a status of homelessness versus conduct such as public drunkenness. The court fairly recently concluded that Martin was binding and that the city's attempt to comply with Martin by removing sleeping wasn't enough. And that's because the camping ordinances in Grants Pass prohibited individuals from sleeping while using any type of item that can be considered bedding. And that can include a blanket, a pillow, a cardboard box. And the court observed that although individuals could still sleep in public places under the ordinances didn't allow using bedding while sleeping. And this is where I think the court kind of took a step further beyond Martin and concluded it's not enough to simply allow sleeping. The Eighth Amendment also prohibits punishment for taking necessary minimal measures to keep themselves warm and dry while sleeping. I think the way the court framed it is the only way you could sleep under the Grants Pass ordinances is to literally sleep on the ground without any sort of bedding, not even a cardboard box. And the court said that is in and of itself cruel and unusual punishment under the Eighth Amendment. My understanding is that Grants Pass intends to appeal that decision to the Ninth Circuit. I think in light of Martin, that will be likely a difficult road for them, but what I'm hopeful, particularly in light of all the difficulties that these decisions have created for cities, that if the Ninth Circuit does not rule in Grants Pass favor, that there's another attempt perhaps to get the US Supreme Court to review these cases and really provide cities and local governments with some guidance as to how to deal with the really difficult problems that homeless presents. And Harry, I'm going to turn it over to you to talk a little bit about what this has meant for cities.
Thank you, Anna. So we have these two decisions. What's next? And how do cities, especially smaller cities and cities throughout Oregon, deal with these two decisions? What services do they have to provide? What laws are constitutional and unconstitutional? These are some of the questions that cities in Oregon, but also all over the Ninth Circuit are facing right now and trying to deal with. As Anna mentioned, the Ninth Circuit is huge. It just covers an enormous swath of land. 2/3 of the United States unsheltered population lives within the Ninth Circuit. So from all the way to Southern California to Alaska, there are cities trying to deal with these decisions and figure out how they can have statutes and ordinances that are compliant, while at the same time providing services to their unsheltered populations. And the decision affects large cities like Los Angeles, Portland, Seattle, San Francisco in different ways than it affects many smaller cities. Smaller cities like North Bend and Coos Bay here in Oregon and throughout the Ninth Circuit that may not have shelters or may have shelters that are in neighboring cities or elsewhere in the county but are not directly within the borders of that city. To give you an example, North Bend, the city of North Bend, does not have a shelter, but the city of Coos Bay, which is directly adjacent to North Bend, does have a shelter. One of the things that the League of Oregon Cities pointed out in their amicus brief is that it's unclear from the Ninth Circuit's ruling whether the fact that a shelter in Coos Bay, just about a mile and a half away from North Bend, whether that would make it illegal for North Bend to enforce anti-sleeping, anti-camping statutes simply because it doesn't have itself a shelter within its own borders. These are the kinds of questions that are left ambiguous by the Ninth Circuit's decision in Martin v. Boise, but it certainly seems like the city of North Bend could face a real challenge because of that. Even cities that have shelters face a number of problems for some of the reasons that Anna pointed out, because shelters often have restrictions and very reasonable restrictions on who can enter, what time they can enter, and in what state they can enter. So for example, many shelters restrict individuals from bringing their pets with them. Other shelters have religious requirements for, as Anna mentioned, attending services. And shelters may have restrictions on the time of entry. For example, they may require people not to enter before a certain time and to be out by a certain time. One of the really difficult questions that hasn't been addressed by court decisions yet is how the coronavirus is going to impact everything that we're facing, everything that cities are facing with shelters here. Coronavirus, as we have all come to deal with and know about, seems to spread in particular during in enclosed spaces. And so a number of shelters and a number of cities have been trying to deal with that, deal with the possibility of spread within enclosed spaces by taking some public health steps. In Multnomah County here in Oregon, some shelters have spaced beds 6 feet apart or farther. Some new sheltering spaces have been opened in Portland. The Oregon Convention Center opened and provided about 120 additional beds. And throughout Oregon, states and counties have been working to provide hotel rooms for individuals who are homeless and who are experiencing symptoms of coronavirus. Certainly, without question, the spread of coronavirus in Oregon and throughout the Ninth Circuit poses a special problem for the enforcement of statutes that prevent sleeping or camping. If shelters are unavailable because of coronavirus, it is highly likely that a court would find that statutes preventing or prohibiting sleeping or camping would be unconstitutional if enforced in that circumstance. So what can you do? What can cities do, and what steps can they take to manage their cities after this decision? Well, the decision appears to present a choice. The choice is either to make sure that there are enough shelter beds available in the city, and if that is the case, either already the beds already exist or new beds are provided, new shelters are built. If enough beds are available, then ordinances that prevent or prohibit sleeping and camping in public spaces may be enforced. Alternatively, a city could choose not to build additional or provide adequate beds, and if that's the case, then those ordinances may not be enforced. That's the choice that the decision seems to present, and it seems to create all kinds of questions about how do you count the number of beds, how do you count the number of unsheltered individuals living in a city, how often do you have to do that, and will estimates suffice? Those types of questions. But there is possibly a middle way, and this is something that courts throughout the Ninth Circuit are working on right now, and we have some early decisions that are pointing some directions for cities. The way is pointed by a footnote in the Ninth Circuit's decision in Martin v. Boise. And the relevant text of the footnote I put on the screen because it's really, really important. What the Ninth Circuit said is that there may be some ordinances that are permissible that restrict lying or sleeping outside if they do so at particular times or in particular locations. And what we as lawyers often call this are reasonable time, place, or manner restrictions. So what we understand the Martin v. Boise decision to be saying is that cities may not impose blanket restrictions on where unsheltered populations, or may not issue a blanket restriction on preventing unsheltered populations from sleeping or camping in public spaces. But there may be some restrictions that prevent sleeping or camping in particular locations or at particular times that are constitutionally permissible. As I mentioned, there
are some court decisions that have tried to flesh out what this means now and what this means for cities. Earlier this year, a court in the Central District of California, a federal court, found that the Martin v. Boise decision was a narrow decision and it shouldn't be used to, quote, expand its holding beyond the criminalization of homelessness. Other courts in California and Washington and Hawaii have followed that decision and have come to similar conclusions that the Martin v. Boise decision should be viewed narrowly. A court in the Northern District of California that was considering a case against the city of Oakland held that the Martin v. Boise decision does not establish a constitutional right to occupy public property indefinitely at anyone's option. And most recently, a court in Hawaii issued a decision that some some ordinances that had been promulgated by a county in Hawaii were in fact constitutional because all they required was permitting in order for people to camp. I think that decision is really a very useful and instructive one for cities here in Oregon. This county in Hawaii has an ordinance that states that if you plan to camp on public land anywhere in the county, you must obtain a permit to do so if your camping structure is erected between certain periods at night. There are a number of other provisions in that ordinance restricting how automobiles are used and where they can be parked and for how long they can be parked. Well, those ordinances were challenged when a police officer approached a group of people who were camping and issued citations to them for not having the proper permits. Those individuals brought a lawsuit against the county in Hawaii, and the district court, the federal district court that heard the lawsuit, found that the county's restrictions were permissible. The court reasoned that the restrictions promulgated by the county in Hawaii were different than the restrictions that had been promulgated by the city of Boise. The city of Boise's restrictions imposed a blanket prohibition on sleeping or camping on public property at any time. But the county's restrictions merely required that a permit be obtained before individuals camped overnight. So the court found that the city of Boise decision did not prohibit the county in Hawaii's restrictions and dismissed the case. There have now been some 30 or so cases that cite to the Martin v. Boise decision. The range of outcomes in those cases is broad. As Anna explained, the decision in Grants Pass seemed to expand the Martin v. Boise decision, but there are some decisions that narrow it. These types of legal issues are being decided on a district court by district court basis all throughout the Ninth Circuit. And until we have another decision from the Ninth Circuit, or potentially in some future case from the United States Supreme Court, it's really going to be unclear exactly how far the decision expands. A decision from a district court in Hawaii or from a district court in California is not binding on any of the federal district courts here in Oregon, but some of those courts may look to the decisions in Hawaii and California and other places in order to try to figure out just how broad the Martin v. Boise decision should be. So what are some things that count as time, place, or manner restrictions that may be permissible? Well, I've put some examples here up on the screen. And as you look at these examples, keep in mind that there are not court decisions on any of these particular examples. So I can't tell you for sure, for example, that a restriction on sleeping within 50 feet of a building entrance would be permissible according to a district court or the Ninth Circuit or the United States Supreme Court. But it's my best guess, my best estimate that a restriction of this kind is likely permissible. Same goes for each of the other 5 restrictions that I've provided as examples here. So why are these potentially permissible? Why do I think that a court would likely allow a city to have restrictions like this? Well, the key to a good time, place, or manner restriction is that the city has a reasonable public safety explanation for why it might be necessary. So 50 feet of a building entrance, exit, driveway, or loading dock, I think that's a pretty easy one to explain to a court. There's a real danger for the individual who might be sleeping, that they could be hit by a car, hit by a truck, otherwise be endangered just simply as a result of the location that they are. Restrictions on sleeping within 500 feet of a school or daycare center. That might be a reasonable restriction simply because of some of the artifacts that come with sleeping or erecting camping gear near a school or daycare. There might be some trash or other things that get discarded that could pose a risk to people who are going in and out of that facility. Restrictions on sleeping on a bike trail obviously could create a danger to both bikers and to the individuals who are sleeping there. Restrictions on sleeping within a public area posted with a no trespass sign. So when I say no trespass sign, it's not enough just to simply say, to put up a sign anywhere that a city doesn't want an individual to be sleeping. There has to be a reason why the sign is there, and it has to be a reason that's connected to some sort of public utility, either the safety of the public or because something else might be going on. Perhaps there's some cleaning going on, replanting of plants or flowers or trees, something of that nature. There has to be a reason why the sign is there. But a city has a right, as a city, to temporarily close off public spaces in order to take care of things that need to be done to maintain the city. And so if a city decides that it needs to remediate a public park, plant new grass, things like that, it should be, and in my estimation, would be permissible for the city to close off temporarily parts of public spaces with a no trespass sign in order to do that kind of work. Finally, I've included a restriction that is based on time. A restriction on sleeping in public areas during certain daylight hours is an example of that. And a good reason why you might, why an ordinance that restricted daytime sleeping might be permissible is because, for example, a public park might be used by general members of the public during the day, and it's reasonable to expect that a city would want to prevent sleeping in spaces that should be usable by the public during daylight hours. Same goes for sleeping on sidewalks or other public spaces during certain hours when the public would otherwise be using those spaces. So what are some other cities doing? How are cities addressing their ordinances and their laws and their unsheltered populations after the Martin v. Boise decision? Well, we've looked at a number of cities to try to get a sense, and it really runs the gamut. A lot of cities, the first group that I want to talk about, are doing a lot of work to build more shelters with the idea that if there are enough shelter beds available, they can move forward with enforcing their ordinances that prohibit sleeping or camping on public lands. The city of Costa Mesa, for example, delayed the enforcement of ordinances that they had that included those sorts of prohibitions until they could complete a new shelter, and they are working on that shelter right now. in Los Angeles, there's a little city, a little municipality right on the coast, right adjacent to Los Angeles, the city of Redondo Beach. And Redondo Beach has done a lot of work with their legal counsel and with partners who are advocating for unsheltered populations and with their own community to try to come up with ways to create small, movable, temporary shelters that allow them to have enough shelter beds on any given night so that they can also enforce their ordinances around sleeping and camping. And so what they've done is created something they call micro shelters. These are very small shelters that they're working on along with a company based out of Seattle that makes them. They are made from reusable materials. They're quite small and easy to transport. These micro shelters are being erected in parking lots, in spaces that are not being used because of COVID and coronavirus that have been closed. And they're being erected for periods of about 90 days or so and then moved around. And that has helped create additional beds for the unsheltered population. They're still working out all the details down there, but it's an interesting and creative solution that tries to avoid creating permanent encampments, but also provide beds and services to the unsheltered population. You may have heard about many of the things that are going on in the city of Olympia in Washington. Olympia has a particularly sizable unsheltered population. About 1.5% of the population of Olympia is homeless. And Olympia doesn't have the resources to provide shelter beds in typical buildings for that entire population. So in December of 2018, Olympia opened what has been called a mitigation site. What they did is they took a parking lot that was near the edge of downtown Olympia. They erected a fence around it, and they erected tents inside the parking lot. And they did so in a pretty deliberate way. It wasn't just fence off an area and let people in and do what they want. They erected tents themselves in kind of an orderly fashion. They did establish some rules for camping in the mitigation site that included a prohibition on the use of drugs and alcohol within the site. But other than that prohibition, and even that one was rather lightly enforced, I understand. Other than that prohibition, there were very few restrictions, and it provided what Olympia hoped to be a cost-effective way to create shelter space for the homeless population there. And the city of Tacoma in Washington has also done a similar type of plan. Olympia's idea was that this space could serve as a temporary space for individuals who were experiencing homelessness, and that they could provide services to help transition those folks from the mitigation site to other housing and off of living off the street. That's been going on for about a year now. There's a nice article in the Seattle Times that looks at the overall effect of the program, and it has had some success in moving people who are experiencing homelessness off the street. Again, Olympia's, Olympia and Tacoma and some of the other cities that are trying this are trying to create the kind of bed space that could potentially allow the enforcement of ordinances. City of Seattle has changed a number of zoning laws to allow more encampments around the city and at different locations, and including in some residential areas. That's a pretty controversial program. So those are some examples of cities that are trying to create more shelter space. Other cities are taking an approach that's based more on the time, place, and manner restrictions that I was just talking about. And I think Honolulu is a good example of that. Honolulu uses restrictions on time and place in order to ban sleeping in some places and at certain hours, but they also expressly allow sleeping in some parks and during certain time periods. And so by closing off some space, but allowing sleeping and camping in other spaces, they've really set forth a really straightforward and easy to understand time, place, and manner restriction. Honolulu also runs a program for short-term housing. That program provides temporary housing for up to 90 days for unsheltered populations in Honolulu. And they used that program in combination with their law enforcement, their city law enforcement. So if law enforcement encounters individual experiencing homelessness who is sleeping in a public space or sleeping on a sidewalk, law enforcement will attempt to divert that individual into the temporary housing provided by the city of Honolulu, rather than issuing a citation or another criminal penalty. And Honolulu's hope is that kind of diversion, where you're moving someone off of a public space, but instead of enforcing a criminal penalty, you're providing them access to housing, is a constitutional and legal way of addressing individuals sleeping in areas where the city would prefer that they did not. Right? And I think that's likely to be permissible under the Ninth Circuit's decision. City of Spokane in Washington, also trying to do something like that, also has regulations that prohibit camping on public property. The City of Spokane, working with their law enforcement, does not enforce those restrictions on camping on public property if the city is unable to verify the availability of a shelter bed. So if law enforcement encounters an individual camping on public space, they do try to divert to an available bed, and if a bed is not available, they do not enforce the statute. All of these solutions, like I said, some are starting to be tested in the courts, but many have not been. And litigation around City of Boise, Martin v. City of Boise decision remains a really big risk all cities face, without question. To give you an example of just how trigger-happy litigants can be right now, you might consider the municipality of Lacey, Washington. Lacey is directly adjacent to Olympia to the east, borders Olympia to the east. And Lacey, the city of Lacey recently enacted a statute that limited the amount of time that individuals can park a recreational vehicle in a parking lot or on a street in the city. The previous restriction had been that no RV could remain parked with an individual living in it for longer than 24 hours. They reduced that time to 4 hours. Almost immediately after they made that restriction down to 4 hours, a lawsuit followed from an individual who was living in a recreational vehicle and was no longer able to park for periods longer than 4 hours. So there are time, place, and manner restrictions that I think are constitutional and we think are constitutional, but everyone should know that they certainly come with the risk of litigation. We as lawyers are trying to figure out what the decision means, what will be constitutional, what will not be constitutional. It can be a tough call, but if you have questions about that and you are thinking about what a reasonable time, place, and manner restriction might be, if your city is considering amending your ordinances or trying to figure out a way to move forward, I certainly encourage you to give Anna or I a call. We can try to help think through some of the ways we might make it constitutional. Or you can always just consider this question. If you were having to explain why your city's time, place, or manner restriction on sleeping or camping was reasonable, imagine that you are in front of a judge and you have to give an explanation why. And you should think, judges are good people. They look for reasonable explanations. They want something that is very specific to your particular location. So a real concrete example of why the restriction is going to protect the public or is for the public good is really what you want to have for each part of the restriction. And you want to avoid stereotyping or generalities that courts will look to cut through. Finally, I thought I'd just mention, as I was looking at some of the decisions that have been, that have followed Martin v. City of Boise, I have noticed some that are popping up from courts that are outside the Ninth Circuit. And as courts in other parts of the United States try to figure out what the Ninth Circuit is doing and what's happening here, I think it is more likely that we will see other Court of Appeals decisions in the other circuits address this question. And I think long-term, that could mean that this issue, even though it didn't go to the Supreme Court this time, is going to go back to the Supreme Court sometime. We'll see. Thank you so much for having us. It's been a real pleasure to speak with you here today. And Anna, I think we would take some questions.
Yeah, thank you.